Good morning. Are you Nasir Brown?
I'm not here today on special appearance.
I'm sorry, speak up so I can
Here
hear you.
today
You're appearing here today?
by special appearance.
Okay, what is your name?
I'm a third party intervener who's behalf of artificial legal entity Nasir Brown.
Okay. At one point in your, at some point in your life prior to being this third party, were you Nasir Brown?
No,
You're not him.
I'm a third party intervener.
So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to, hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
That's relative.
So are you Nasir Lewis Brown, or have you been him at some point in your life or not?
Yes.
Okay. So I'm going to call you by Mr. Brown because I'm not going to say all the words that you just said because you have now identified yourself as Nasir Lewis Brown. And so, Mr. Brown, this is your initial appearance and you have two cases. And cause number 26, I just asked you not to speak over me. So here's the thing, Mr. Brown. I'm going to be very
I
patient.
had the child subject matter jurisdiction for on record.
Your challenge of the subject matter jurisdiction is overruled. Let me go through what I need to go through, okay? So this is your initial appearance, your first day in court. I'm required to go through what you're charged with by indictment. In cause number 26, DCCR 0322, you're charged with a third-degree felony offense of assault family violence by impeding breath or circulation from February 16th of 2026. And then in cause number 26, DCCR 0323, you're charged with the state jail felony offense of injury to a child, and that's from February 16th of 2026. And so since you have made bond and got out of jail on your cases, have you had an opportunity to try to hire a lawyer?
This is what I'm saying.
Speak up so I
Been
can.
up and down.
It's been up and down?
Yes.
Okay, so here's what I'm going to do, Mr. Brown, is I'm just like everyone else. I'm resetting your case about 30 days to give you some time to try to hire a lawyer. You need to try to get someone hired before the next court date. If you do, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order and you would go back to jail. Do you understand? I'm sorry?
Overstand.
Say it
They
again.
overstand.
You overstand?
Yes.
Okay. What does that mean?
Overstand.
Do you understand what I'm saying, sir?
I'm blind.
You'll oblige.
I'm blind. Yeah.
Okay. You just determined to use different words and be difficult, aren't you?
No.
Okay. So as a condition of your bond, did you have a condition that you were not to have any contact or communication with the complaining witnesses in each of these cases, right? Okay. And so I want to make sure you understand the importance of that. And that if you do have any contact or communication with either of them, it would be a violation of that bond condition. If I find out, your bond would be raised and you would go back to jail. Do you understand that as well?
Overstand.
You overstand.
Same thing.
I'm going to guess that overstand is even better than understand. So you definitely know what I'm talking about, right? So we don't have any miscommunication today. You know exactly what I'm talking about. So I'm going to have you step in front of the clerk. You're going to sign a reset notice so you know when to be back in court and take care of those things before the next court date. All right, step in front of the clerk. Good morning, sir. Are you Andre Williams II?
Yes.
And this is cause number 24, DCCR 2286. I am going to take judicial notice of the court's file before we go forward. It looks like last year there was an evaluation for competency to stand trial. And Dr. Rapon evaluated Mr. Williams and found that he was competent. Is there any other issues with regard to competency that we need to take care of today?
No, Your Honor. No, Your Honor.
All right. Then will your client waive the formal reading of the indictment?
Yes, ma'am.
All right, sir. In cause number 24, DCCR 2286, You're charged with a first-degree felony offense of murder, and that's from October 13th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Vasquez? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence other than what we've already gone over about any competency issues with Mr. Williams?
No, Your Honor.
All right, then, Mr. Williams, at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Find again you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the offense of murder. Sentence you in accordance with your agreement to a term of 40 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification, right, that shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Vasquez. And Mr. Vasquez, if you and Mr. Williams will please have a seat at council table. We have a victim impact statement. We'll go off the record for that. Have a seat over there, sir. Tuska, you have Traylon Hill. Our favorite. Good morning.
Good morning, Your Honor.
Yeah, I don't.
Yeah.
Just more. I'm not gonna. I'm done talking to him about it. Nobody's talking to you right now, okay? Don't say, Mr. Hill, don't say a word unless someone asks you a question, okay? All right, so Mr. Hill's cases are set for trial to begin with jury selection next week. And Mr. Matuska, you filed a motion for continuance.
I did, Your Honor. At the last setting, Your Honor, the court informed me that this case was urgent. We did receive all the discovery. I printed out all the reports and provided a notebook to the jail. I've gone down there with the laptop. The guards at the jail have informed me that Mr. Hill is refusing to come out and meet with me, to go over his discovery with me.
Okay.
And I have not had an opportunity to show him based
Don't
on-
talk. I'm going to talk to you in a minute. Don't talk over people.
I'm not talking over him.
You're talking over me right now, and you're talking over him. Mr. Matuska,
Based upon that information I'm receiving from the guards, I've also reached out to the family, Your Honor. They seem concerned for some other reasons
I haven't been out to the cell in over
that
like
the court may be
5
aware of.
weeks.
But I have made efforts to provide him the opportunity to see his discovery, but the jail is telling me he's refusing to do it.
all right, so I'm going to grant the motion for continuance. I am also going to go ahead and order an evaluation be done. Mr. Hill, it's very important if Mr. Matuska or any doctor or anyone comes out to visit you, that you visit with them. It's going to help move your case along, okay?
Cool.
So
I
it's
paid for Burbank. I don't even know who this is.
so Mr. Burbank has not been paid because he's not here to represent you. Mr. Matuska is your lawyer.
You can put up his file.
I appointed Mr. Matuska, who is an excellent attorney, to represent you. Mr. Burbank got off of your case.
But the reason why is 'cause
listen.
I've been to court 14 times, and I'm looking to go because I have no evidence on me.
Listen,
during this whole entire
you and me both are ready
So
for
y'all
you to
invaded
go.
y'all invaded
Both
my
of us. So
community.
go back with the bailiff.
Y'all invaded
Listen,
my
if they
community.
come out to visit
All my
with you, you need to visit with
constitutional
them.
amendments
Go back
y'all
with the
made.
bailiff.
Hey, watch where you hold me, sir. Don't touch me like that, man. You ain't gotta touch me. I know how to walk, sir. All right, you just don't get it at all.
Your Honor, after the evaluation, maybe another way that we could order some kind of setting where I can just give him the opportunity to see him.
Yeah, I can, what we can do after that's done and we get it, if we need to, we can have him, I'll contact the jail and see if we can either have him brought here with cards or you somewhere at the jail where I'll order that they force